Hello everyone and welcome to the lecture series for the preparation of CLAT examination. In this particular lecture series, we are discussing about the important areas for the preparation of CLAT examinations, specifically focusing over the legal research, the legal reasoning portion of your CLAT syllabus. In our previous videos, we have discussed majority of the legislations. We have discussed about the Indian Contract Act. We have discussed about the criminal laws. We have also talked about the law of torts. And from a few videos onwards, we are discussing about the family laws. We have, for now, we have discussed about the overview of what are exactly the sources of the family law. We have discussed about an official syllabus of your CLAT examination in regards to family law. We have talked about the different sources in regards to Hindu laws. We have talked about the different sources in regards to Muslim laws, and from this lecture series onwards, we are going to discuss about in a detailed discussion. We are going to discuss about how these legislations, which are the sources of the family law, are helping in formulating and guiding and providing a way through of how the marriages needs to take place and what are the rules and regulations behind it. When you talk about CLAT examinations as such, these legislations, when you will study these legislations will come up handy in finding out, in figuring out that whether a marriage, if it has happened, whether that marriage is a valid marriage or not, what are the conditions of a valid marriage, and what are the requisites which one should follow once they want that the marriage, whatsoever people are going to be governed through this marriage. So when we talk about the Hindu Marriage Act 1955, as you can see over the screen if it is visible to you, that the Hindu Marriage Act, when we talk about the Hindu Marriage Act of 1955, it is an act that is only related to Hindus. It is only related to Hindus. And we will be studying in detail that how this act is the only act in regards to the Hindus by religion that whenever there is a marriage that is going to take place between one Hindu and another Hindu, then this particular legislation will come up handy in figuring out whether that particular marriage has been able to abide by all the requisites or all the essentials that has been made in this particular legislation. So even if you're getting married, so it doesn't mean that if for example, if there is one person A and the other person is B, A by virtue of its religion is a Hindu and B also is a Hindu, then by default this legislation is going to be applicable over both the persons A and B. So their marriage will be solemnized according to the legislation or according to the rules that has been mentioned under the Hindu Marriage Act of 1955. Now, what you need to remember here is that it is not like that if there is one Hindu and another religion, there is a person from another religion, then whether this act will be applicable or not. The answer is no. Answer is no. The reason is this act shall be made applicable only when there is a marriage between two individuals who come from the same religion, that is Hindu. Now the question is, according to this legislation, what exactly is a Hindu? What exactly is a Hindu? So for that, we will be reading this particular legislation. We will try to understand that according to this particular legislation, the Hindu Marriage Act of 1955, who exactly is a Hindu and how the marriage will be solemnized in order to make sure that this particular marriage that is going to happen according to the Hindu Marriage Act of 1955 is a valid marriage. Okay, is a valid marriage. Now, what is valid marriage here? Valid marriage means that this marriage is a legally valid marriage in the eyes of law, and all the matrimonial rights which a person gets whenever they are marrying, those rights will be granted by virtue of this particular legislation only. Whether you are talking about your consummation of marriage, whether you are talking about restitution of your conjugal rights, whether you are talking about maintenance, all these rights, where will you be able to get these rights from? It is this particular legislation which is actually going to provide you with all the rights and what are the obligations once a marriage is solemnized, and how a marriage will be considered to be as legally valid marriage. That is something that we'll be studying in this particular legislation. And for your CLAT point of view, this particular legislation is very important because this legislation is going to provide you with the requisites or the essentials of a valid marriage. So in order to make sure that the marriage is going to be a valid marriage, this legislation needs to be understood by the CLAT aspirants, because when you'll get questions in your CLAT examination, then there will be a hypothetical situation that will be put in front of you. There will be a paragraph in which it will be mentioned that A married X, who is of 17 years of age or 16 years of age or 19 years of age, and then the marriage was solemnized. Okay, now whether that marriage is a valid marriage, a void marriage, or a voidable marriage. We have studied in our contract there are three types of marriages, or three types. First is valid, second is void, and the third is voidable. So when you talk about Hindu marriages also, these type of marriages are there, and valid marriage is something where which all the requisites or the essentials that is required according to the Hindu Marriage Act of 1955 has been followed. If the marriage is not been able to follow the legislation, the laws that has been mentioned in the Hindu Marriage Act, then that marriage will be considered either void marriage or voidable marriage. Voidable marriage means that the marriage is still valid in the eyes of law, but if the other party feels like there are two people who are going to get married, right? So if there is one person who feels that this marriage is not with free consent, okay, or there is some force that has been applied to it, or maybe he or she was not of the age when the marriage should have been done, but any which ways they got married. So at that point of time, there are certain requisites or certain essentials or certain rules that needs to be followed. So if those rules are being followed and that wrong has been removed, then that marriage from being considered as a voidable marriage will now be considered as a valid marriage. And if the rules and regulations which are supposed to be followed has not been followed, then that voidable marriage will be converted into void marriage. So when we talk about voidable as such, so voidable actually means which can be converted into a void marriage. But at that point of time, when it is being considered as a voidable marriage, then this marriage is still valid in the eyes of law. But if any of the two parties who have married, if they contest by going to the court or by sending an application to the court that this marriage is not a valid marriage according to me, and I've been forced to continue with this marriage, I want to seek relief from the honorable court, then that point of time the court will see through it that what are the essentials that has to be followed according to the Hindu Marriage Act, whether those essentials has been followed or not. If they feel like that those essentials has not been abided by, they will convert this marriage, a voidable marriage, into a void marriage, and that marriage will be of no validity. It will be considered that these two people, let's take example, A and B has not been married so far until unless that marriage has been considered as a valid marriage in the eyes of law, or more specifically according to the court. So let's start and let's try to understand that what exactly are the important legislations or the important sections of the Hindu Marriage Act which is going to govern the the marriages between two Hindus. So for that, first and foremost, we'll understand what exactly is a Hindu and to whom. Okay, so let's just summarize that what are the things that we are going to study in the Hindu Marriage Act. The first thing is we are going to study is who is a Hindu. Okay, who is a Hindu? Then we will study essentials of a marriage. Essentials of marriage. Then we will study about competency of marriage, that who all are competent to get married, and then we will study that what exactly is a void, voidable, and valid marriage. So these are the things that are important for your CLAT perspective in regards to the Hindu Marriage Act 1955, and we will be confining our study only in regards to these 4 important points that has been mentioned here. That first we'll understand what exactly is a Hindu. Then after understanding what is a Hindu, we'll study what are the essentials of marriage, who all are competent to get married according to the Hindu Marriage Act of 1955, and what exactly is a void, voidable, and valid marriage according to the Hindu Marriage Act of 1955. So let's start with our lecture. I suppose you can see the screen now. This is the arrangement of sections when you talk about the Hindu Marriage Act HMA of 1955, and this is how we are going to represent it in our coming lectures, because the Hindu Marriage Act, this is the short form that is used. The first section talks about short title and extent. The second one talks about the application of the act. The third is the definitions, which will be providing us all the definitions that will be coming up handy in understanding all definitions to understand this legislation. Okay, and overriding effect of the act. So if there is any other law or legislation which is talking about marriage between two Hindus, so that will be overridden by this act, and how this act will be applicable will be taken into consideration. Then what are the conditions of a Hindu marriage? That is what we need to study. Then ceremonies of Hindu marriage, that what exactly are the ceremonies that needs to be performed if at all we want the marriage to be a valid marriage. Okay, so all of these things that we are studying, it is going to help us in figuring out that if at all these requisites are being followed, or all these essentials are being followed, then that marriage will be considered as a valid marriage. So what will be the benefit of it? Why do we want the marriage to be a valid marriage? Okay, there are two people who came together, who decided to get married. What is the point of bringing law into it? Why do we need law? The answer is because whenever you are going to get married, it is going to provide you with variety of rights, and not only rights, there will be certain obligations over you according to the marriage. So if you want to get those rights, for example, you talk about inheritance. If there is a husband and a wife and the marriage is not considered to be a valid marriage, then the wife shall not get any share from the property of the husband. And in the same way, if the marriage is not a valid marriage, then the wife estate, means the wife's property, shall not be given to husband, or even the heirs of the husband. So you see that if the marriage at all is not being considered as a valid marriage, then the outcome would be that that particular inheritance, succession, division of the property will come up in question, and that will obviously be a setback for a person who has been married for around 10 or 11 years and they come to know that they cannot inherit the property of their spouse, the reason being the marriage is not being considered as a valid marriage in the eyes of law. So this is something which is obviously very important point of discussion. And when you talk about understanding this particular legislation for your CLAT perspective, so these are the things that will be put up in front of you, and the chances are that the questions will be very much straightforward. But since the students are not able to understand the legislations as such, and they often, what they do is they often make silly mistakes when you talk about family law, because there is always a sort of an overconfidence in the students that this is something that we are already acquainted with. And once we get an idea, a shallow idea will also be helpful for us to get a passing marks in this particular legislation. But truth be told, this legislations is very short and very easily understandable, but we have to understand all the sections in a correct manner, so that we don't get confused whenever the questions will be put in front of you. And I've just explained to you how the questions would be when you talk about CLAT examinations. The questions will be in a form of a paragraph, where which you will be asked that, okay, there is a person A and a person B who got married in the year of that 1976 or 1972 or 1950 or 2010, any random date. And then you will be told that this was the condition when the marriage took place. They were not able to take 7 rounds against the holy fire, or whether this marriage is considered to be a valid marriage or not. So in order to understand that whether the marriage was a valid marriage or not, first you need to understand the conditions. Yes. And you need to see that whether all the ceremonies which is required to be for a valid marriage needs to be fulfilled or not, whether registration of a Hindu marriage is necessary in order to get all the rights and remedies. So all these things you will be understanding in our coming lecture or in this particular lecture. Then what is restitution of conjugal rights? Conjugal means those rights which you get on marriage. Right to cohabit with your partner. Right to cohabit with partner. Right to sexual intercourse. Right to maintenance. Right to inheritance. So all these rights will be given to you only when your marriage is a valid marriage. So we need to understand, it is very important to understand that what are the actual conditions that needs to be fulfilled in order to have a marriage as a valid marriage. Then in this particular legislation only, we will be studying about what is judicial separation. So marriage is done, everything is clear. But now if the husband or the wife doesn't feel like that their marriage is going to be continue for a longer period of time, and there are lots of conflicts that are coming in between their marriages. So what is the ground, or how come they can take a divorce? This is also has been mentioned under the Hindu Marriage Act only. Now we will also be studying about void marriages. I just informed you, voidable marriages. We will also study about divorce. Divorce is something that is also important to understand, that when a person can claim divorce. And apart from that, what we will study is whenever there is a divorce proceedings. So if there are two people, A and B, they got married. Now there is conflicts and trifles between A and B. They decide that, okay, fine, we want that we should move to separate paths, and we should not continue with this marriage. They file for divorce. There are two types of divorce here. One is divorce by mutual consent. Okay. And then there is another divorce which is known as contested divorce. So mutual divorce by mutual consent means both the parties, A and B, feels like that their marriage is not going to sustain and there is no point of continuing with this marriage, and they want that the marriage should be nullified and they can move forward with their own lives. So they file a petition, an application to the district court or the area in which they are residing, in the area in which they are residing, in that particular jurisdiction they will go and they will file a case of divorce by mutual consent. So once they file a case of divorce or mutual consent, the court will hear their matter and they will ask that what exactly is the reason for you to not continue with this marriage. They will tell their reasons. The magistrate will record their statement in writing, and after a certain period of time, whatever obviously the requisites that has been mentioned under this particular legislation needs to be followed. So after a certain period of time, the magistrate will grant divorce to them. So in the same way, there is this is mutual divorce, but there are chances that out of these two people, only A wants to give divorce and B doesn't want to give divorce. In that scenario, it will be considered as a contested divorce, meaning which A will say that these are the reasons I don't want to continue with B, and B will provide reasons as to why he or she doesn't want to give divorce to A. And that is something which is known as contested divorce. And this is something that we will be covering under section 30. Okay, divorce. Now there are various grounds on which a single person can even ask for divorce. But what exactly are the grounds on which a person without any the solid grounds, they cannot give divorce? Because in the very when this particular marriage was being considered as a legislation to be created in regards to marriages, it was considered, and it is still being considered, that in Hindus, marriage is not a contract, but rather it is a sacrament. And since it is a sacrament, it becomes essential that when we talk about the ceremonies, when we talk about the conditions, all these conditions need, and when we talk about application, all these things needs to be fulfilled in order to make that marriage a legally wedded or legally binding marriage. So we need to understand that unlike Muslims, where which the marriage is considered to be a contract, in Hindus it is considered to be a sacrament. Okay, so we will study the void marriages also, voidable marriages also, what is divorce, alternative relief in divorce proceedings, what are the reliefs that we can claim, okay, whenever there is divorce, what is exactly divorce by mutual consent, no petition for divorce to be presented within 1 year of the marriage. Okay, so no petition for divorce to be presented within 1 year of marriage. So you cannot present a petition before 1 year of marriage. So obviously this is something that has to be in question. Divorced person when may marry again. Okay, so when they can marry again, legitimacy of a child of a void and voidable marriages, what happens to if a child has been born, then what exactly are the grounds? That is what we are going to study also. Then apart from that, we are going to study what is punishment for bigamy. Bigamy is something where which bigamy means marrying again when your spouse is still alive or you are still married. So if somebody marries during their continuing marriage, so for example, there is a person A and B, and A and B has consummated a marriage, both are legally wedded, and A now decides to marry C when B is also present. So that is something which is not allowed according to the Hindu Marriage Act of 1955. So we need to understand here also that in Hindus, we only allow monogamy. What is monogamy? That one husband and one wife. There cannot be more than one husband, there cannot be more than one wife in regards to marriage. So that is something that we need to understand. And then we'll be discussing about punishment for contravention of certain other conditions for a Hindu marriage. That what are the grounds if you are not able to comply by, then what will happen? to court to which the petition shall be presented. That is something which we'll be studying overficially, because you are not supposed to understand that which court they have to go. Then contents and verifications of petition, that is something we'll be studying overficially only. Application of Act 5 of 1908, this is something which is not talking about code of civil procedure, that whatsoever directions or the court proceedings will take place, it will be according to the code of civil procedure only. So even if there is a marriage, there is a divorce petition that has been put up in question in the court, then the procedure that has to be followed will be the code of civil procedure that will be made applicable. And power to transfer petitions in certain cases, that is also we're going to summarize and understand. Then what are the special provisions relating to trial and disposal of petition under this act? This is also what we're going to study. Documentary evidence, proceedings to be in camera and may not be printed or published. So it cannot be published and printed. That what exactly are the proceedings that are going on. And degree, that how the degree will be passed. Relief for respondent in divorce and other proceedings. Maintenance pendent light. What exactly is maintenance pendent light? This is something which is known as interim maintenance. Interim maintenance means maintenance during the pendency of the case. So if somebody has filed a case of divorce, then obviously a person, let's take example, there is a person A. Okay, A is wife and B is husband. Now, A was given divorce by B. A had no source of income. And when she married B, who happened to be a rich person, the whole lifestyle of A changed for a continuous period of 5 years. Let's take this as an example. Now, after 5 years, husband decided that I don't want to continue my marriage with A because of certain conflicts or maybe any other dispositions. So at that point of time, A has the right to claim maintenance pendent line, because since she has no source of income, she will be asked that, okay, since my rights has been curtailed, the rights that I got because of the marriage, that is the conjugal rights, I want my rights to be restored, and for that I want maintenance. So for that maintenance, for that amount, she can file a application in the court, and then obviously the court will listen to that particular matter. Then what is permanent alimony and maintenance? So for example, there is a divorce that is going to take place. So for that, what we are going to do is we are going to provide a permanent alimony. Alimony is an amount that is being paid to the person who has who will be given divorce, or who doesn't want to continue with the marriage. That person will be providing alimony and maintenance to the person to whom they are going to divorce. And this is something that is according to the Hindu Marriage Act. It is compulsory that you be provided with alimony in regards to divorce, which you are giving on pretext of section 13, which is talking about divorce, which is not mutual in nature. So if there is mutual consent, then obviously alimony and maintenance is something that will be decided outside the court. But if you're talking about divorce, that is according to section 13. That is what we are going to study in a few minutes time. That will entertain permanent alimony, maintenance pendent line, and everything. So this is our source of revenue or amount that will be provided to the aggrieved person, the person to whom the divorce is being given, because this will help in assuring that the person whose conjugal rights has been violated because the person to whom the marriage was consummated doesn't want to continue with the marriage. So a sort of a relief is being provided through section 24 and 25, which is talking about maintenance pendent light and permanent alimony. Then we also talk about custody of children, to whom the children will be given the custody if at all there are chances that the marriage is being solemnized. Then how the property will be disposed of, and appeals from decree and some orders whenever there is a decree or order to whom the appeal will be passed, and enforcement of decrees and orders. This also we are going to study. So these are the important things that we are going to study in our legislation, that is the Hindu Marriage Act of 1955. So let's start and let's try to understand and analyze the first and the foremost thing which is in regards to the Hindu marriage, and that is who exactly will be considered as a Hindu. Before that, small introduction about this legislation. This act, that is this legislation, the Hindu Marriage Act 1955, is made to amend and codify the laws relating to the marriages among Hindus. Okay, marriages among Hindus, and it was codified, or it was enacted in the 6th year of the Republic as follows. Okay, so 18th of May 1955 came into force. What is this name? This act shall be called the Hindu Marriage Act of 1955. This is already clear, so you need not delve deep into it. That is something that is already self-explanatory. It extends to whole of India. Earlier, it was except Jammu and Kashmir. It was except the Jammu and Kashmir, it was not applicable. But after the Article 370 was abrogated, abrogation of Article 370 and the special privilege that was given to Jammu and Kashmir, which has now been curtailed, the act became applicable to Jammu and Kashmir also. So now it is applicable to whole of India. Okay, now it is applicable to whole of India and applies also to Hindus domiciled in the territory to which this act extends, who are outside the said territories. For example, what does that mean? It means, for example, there is one person A. He happens to be present in America, but he is Hindu. He is a Hindu and he is domiciled. Domicile means he has a place of residence and his nationality is also Indian. And by religion, he is a Hindu. So if these three requisites are being fulfilled, so that person will be considered as domiciled in the territories to which this act extends, means throughout the India. If somebody has been domiciled, then this act, and he is a Hindu by nature. So even if he is in America, he is in Germany, he is in Sri Lanka, whatsoever the places, but since he is a Hindu and he has a domicile, a place of residence in the territory of India, he is by religion he is a Hindu, and by nationality he is an Indian. Then this act will be made applicable to that Hindu also, who are outside the said territories. Correct? Understood? To any person who is a Hindu by religion. Okay. So now, to whom this act will be applicable? To any person who is a Hindu by religion in any of its forms or development. Okay, so it will, whether it is a Hindu from Uttar Pradesh, from Maharashtra, from Delhi, from Kerala, any place within the territory of India, if that person is Hindu, then this act will be made applicable to that particular Hindu. Okay, that act will be made applicable to that particular Hindu. And it also includes, these are the things that you need to just keep in mind. First is Veerashaiv, Lingayat, or followers of the Brahmo, Prarthana, or Arya Samaj. So these are the different sect of the society or the community which have been considered also Hindus, although the way they worship is a slightly different from the way the Hindus worship. Hindus have various gods, but when you talk about Lingayats and Brahmos specifically, there are only one god they are going to worship. So this is a small difference when you talk about Veerashaiva, Lingayat, and Brahmo, and Prarthana, and Arya Samaj. But majority of the ceremonies, all the culture that is being followed is according to the Hindus only. So that is why this act has included under the domain name of Hindu, not only Hindus, but Veerashaiva first, the second one is Lingayat, third one is Brahmo, fourth is prarthana, and fifth one is Arya Samaj. Now, why am I telling you all this? How is it relevant for your CLAT preparation? Because once you will get the question paper in your hand, the first thing that they will be mentioning is, if at all there will be a question in regards to the application of this act, that there is a person A who married to B, who happens to be from a community belonging to Brahmo Samaj. And then there will be another stories that will be mentioned. So now the student tend to get confused that if it is mentioned Brahmo Samaj, that it means that this is not being considered under the Hindus. So this act shall not be applicable. Right? So this is a misconception that the students have. What it tends to do is that it results in a marking the wrong answer, because obviously once we study the legislation, we come to know that under the domain name of Hindus, Virashivai, Lingayat, Brahmo, Prarthana and Arya Samaj is also included. So whenever there is any ceremony which is being taking place on the basis of the culture or the ceremonies which is being included under the Lingayats, Brahmo Samaj, Prarthana, Arya Samaj, all these will be considered as a valid ceremonies, and under the Hindu domain name, all these communities are also included. To any person, so this was about the communities. These 5 communities are included under the domain name of Hindus. Apart from that, to any person who is a Buddhist, Jain or Sikh by religion. So a Buddhist, a Jain or Sikh are also considered to be Hindu according to the Hindu Marriage Act of 1955, which means that if you are a Buddhist, if you are a Jain, or even if you are a Sikh, you have to abide by the terms of the Hindu Marriage Act of 1955 in order to consummate a marriage which is considered to be a valid marriage, and all the conjugal rights that will come up with the legality and the validity of that particular marriage will be given to the spouses. And so this was about the to whom this act will be applicable. So we came to know that under the domain of Hindu, it will not only include all the 5 communities, that is your Lingayat, Virashivai, Lingayat, Brahmo Samaj, Arya Samaj. It also includes Buddhist, Jain and Sikh. Buddhist, Jain and Sikh. But what it does not include, this is something that now we have understood, that it includes Buddhist, Jain and Sikh and all the 5 communities, and obviously the normal Hindus who are being mentioned according to their cultures and ceremonies. But it does not include. It will include to any person domiciled in the territories to which this act extends. So it means that this act is applicable to almost everyone who is domiciled in the territories to which this act extends. But who is not included is, first and foremost, the first one is Muslims. So Muslims are not being considered under the Hindu Marriage Act, so they will not be governed by this. Christians are also not being considered. The third one is Parsi. Fourth is Jew. So these 4 people coming from these 4 religions will not be governed through this particular legislation until and unless it is proved that any such person would not have been governed by the Hindu law or by any custom or usage as part of that law in respect of any of the matters dealt with herein, if this act has not been passed. Meaning which, these 4 will not be included, that is for sure. These 4 will not be included. But if there is any person who is domiciled within the territory of India, and it is being shown that the laws which is in regards to the Hindus is being governed as a matter of their customs, usage, or part of their laws, then that person will also be governed by the Hindu Marriage Act. Meaning which these four communities, Muslims, Christians, Parsi, Jews, not applicable, understood. But apart from that, if there is any person who is domiciled in the territories to which this act extends, means this act extends throughout the territory of India. So if there is anybody who is staying or who is domiciled within the territory of India, and the customs and the usages which are actually resonating to the laws or the rules that has been under the Hindu laws, then that person shall also be governed by the Hindu Marriage Act of 1955, until and unless they show that there is a contradiction or there is a difference in their customs which is making them not applicable to this particular legislation. The following persons are Hindus, Buddhists, Jain or Sikh by religions, as the case may be. Any child, legitimate or illegitimate, both of whose parents are Hindu, Buddhist, Jain or Sikhs by religion. Okay, so if there is any child, okay, any child whose both of whose parents, okay, so let's take example. There is a question that there is one person X. There is one person X who happens to be the son of A and B, both being Hindu. Then by default, X will also be a Hindu. If both A and B are Jain, and let's take example, one is Jain and another is Hindu, then again it will be considered that X is a Hindu. If it is, instead of Jain, it is a Buddhist, another is Hindu, then also it will be considered as a Hindu. If there are two people, one is Jain, another is Buddhist, then also they will be the X will be considered as a Hindu. So it is making sure, and it is not only the legitimate child, even if there is an illegitimate child, okay, illegitimate child, then also that child, if at all either of the parents A and B are Hindus, then the child will also be Hindu. But what if there is one Hindu and another of maybe a Christian or a Muslim? Then what would X be considered? Any child, legitimate or illegitimate, one of whose parents is Hindu, Buddhist, Jain, Sikh or by religion, who is brought up as a member of a tribe, community, group or family to which such parents belonged, and any person who is a convert or reconvert to a Hindu, Buddhist, Jain or religion. So means that even if one person, one parent is Hindu, then, and the upbringing of that child, is according to Hindu community, then also that child will be considered as a Hindu. Okay. And any person who is a convert or reconvert by this particular religion, then also he will be considered as a Hindu. This is something that we are not going to study. This is talking about the Article 366. Article 366 of the Constitution, which talks about the scheduled tribes. Within the meaning of this clause, by the notification, it says that if there is any community which is falling under the Article 366 of the Constitution, then this act shall not be applicable. This act shall not be applicable until unless the central government by notification, the official gazette, otherwise direct. So if the central government has directed that, okay, this particular community shall be considered to be a Hindu, then even if they are falling within the brackets of Article 366 of the Constitution, they will be considered as a Hindu until unless the central government has not declared such a by official gazette notification that this particular community should be considered as Hindu. They shall not be governed by this particular act. So there are three conditions. Three conditions when this act shall not be applicable. First, if you belong to community which is Muslim, Christian, Parsi or Jew, this is the first condition. Second condition is either of the parents are not Hindus and upbringing not according to Hindu community. And the third one is they are falling under Article 366 of the Constitution, and central government has not by official gazette directed that particular community be considered as a Hindu. Understood? So these are the three requisites when a person shall not be considered to be a Hindu. Apart from that, the expression Hindu will include all those people who have not been under these three conditions. So everybody shall be considered Hindu if at all it is talking about marriages. The expression Hindu in any portion of this act shall be construed as if it includes a person who, though not a Hindu by religion, is nevertheless a person to whom this act applies by virtue of the provisions contained in this section. Okay, so this is what is applicability of this particular legislation. So we came to a conclusion that only there are only perhaps three conditions based on which a person shall not be considered to be a Hindu. First is they belong to the religion of Muslims, Christians, Parsi and Jews. Second, they are falling within the brackets of Article 366 of the Constitution. And third, neither of the parents are Hindus, and the person has not been brought up as a Hindu. So these are the conditions. If at all they are not being fulfilled, then they will not be considered as Hindu. Rest everybody is being considered Hindu according to the Hindu Marriage Act of 1955. So these are definitions that that is going to be helpful for us to understand that what exactly this legislation is talking about. The first is talking about the customs. Customs means a continuous and uniform observed for a long period of time has obtained the force of law among Hindus in any local area, tribe, community, group or family. So customs we have already studied. I have told you what are the important essentials when we talk about the customs. So that is the only thing that we need to follow when we talk about customs. So custom is the same definition that we have already studied. And provided that the rule is certain and not unreasonable and opposed to the public policy. So this is an exception, that custom shall not be considered as a valid custom if it is opposed to public policy. And that in the case of rule applicable only to a family, it has not been discontinued by the family. So there should be continuity. So all the essentials that we have studied when we were talking about customs in our earlier video, that is the same requisite that we need to follow when you talk about customs in regards to the Hindu Marriage Act also. Then you have district code. That is something we already know, that in areas there is a city, a civil code, and in other areas the principal civil code of original jurisdiction. and it includes any other civil court which may be specified by the state government by notification in official gazette as having jurisdiction in respect of matters dealing in with this. So district court is that court which is going to entertain that particular area when there is a city, where in any area for which there is a city civil court, that court, and in any other area the principal civil court of original jurisdiction. Okay, so this is something you need to remember. Full blood and half blood, important, because sometimes there will be questions and you need to do what exactly is full blood and half blood. Two persons are said to be related to each other by full blood when they are descendant from a common ancestors by the same wife, and by half blood when they are descendant from common ancestors but different wives. So half blood and full blood. So there is a person, okay, H, and this is the wife. There is another wife. Okay, so let's make a chain here for your better understanding. Now from this wife, this particular husband has one son and one daughter, and with this wife they had one son. So now how come these two people will be related? Obviously they will be considered as brothers, but they will be considered as half brothers or half blood brothers. The reason being, they are not sharing the common ancestors between them. Had that been the scenario, if you talk about these two people, S, one son and the daughter, they are full blood. They are full blood because they are coming from the same ancestors. But when you talk about different wives, so the ancestors have changed. So now this particular son is obviously the brother of this particular person because he has the father same and wife different, but it will not be considered as full blood because the wife or the mother is different in both the cases. The father might be the same, but since the mother is different, so the relation between these two, as son and son, this H person who happens to be the husband, both of them will have same father but different mothers. So they will be considered as half blood relations. I suppose you are now being able to understand what is full blood and half blood. So this is what is important. Now what is uterine blood? Two persons are said to be related to each other by uterine blood when they are descendants from a common ancestress but different husband. Now there are two husbands again. Okay, there is some single wife. Okay, and from this husband, the wife had one son, and from this husband, the wife had another daughter. Okay, and this is perhaps possible. Why? Let's take the example. Husband died. This husband died. After the death, wife again married to this person. Okay, this is H2. Let's take the example of H1 and H2. Now, from this husband, this wife had another daughter. Now the question is, what will be the relation between these two people? This is son and daughter of a same wife. How will they be related to each other? Obviously, they will be brother and sister. But the relation will be considered as a uterine blood relation because they share perhaps the same ancestress but different husbands. Means the father is different but the wife or the mother is the same. Since the mother is the same, they will be considered to be in relation as a uterine blood and not full blood. And for your better understanding, I would like to tell you here that full blood is a more stronger bond than half blood, and then comes uterine blood. And this is important for you to remember because when you talk about inheritance, when you talk about succession, then obviously full blood is always considered over half blood and then the uterine blood. So this is something that you need to remember and retain. This is important. What is full blood, what is half blood, and what is uterine blood. Okay. In clauses C and D, ancestors includes fathers and ancestors to the mothers. Okay, this is something that now Sapinda relation. What is Sapinda relationship? We have understood. Okay, now what we are saying is that whenever we are going to get married, okay, whenever we are going to get married, we cannot marry in same pind. Now, what does that mean? With reference to any person, extends as far as third generation, including the line of ascent through the mother. Okay, now let's take example. This is a person X. He has a mother, another mother's mother, and then you have mother's mother's mother. Okay, so this is in short, you can say a grandmother, and this is your great grandmother. Let me just produce in a better way so that you can understand it. So let's take example. This is X. Okay, this is mother of X. This is father of X. Then you have mother's mother, that is grandmother. So this is mother's mother, grandmother. Then you have mother's mother's mother, that is great grandmother. Okay, so this is 3 lines of ascents. This is ascent, this is going up. Okay, this is 3 as far as 3 generation in the line of ascents to the mother. Okay, and 5/5 in the line of ascents to the father. Now this is father, this is 1. This is father's father, this is 2. This is father's father's father, great grandfather. Then this is father's father, father's father. This is great great grandfather. Then you have father's 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 father, great 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 grandfather. So what is it saying? And ascends through the father, the line being traced upward in each case from the person concerned. Okay, this is the person concerned who is to be counted as the first generation. This is the first generation. Okay, this is the first generation. Now what it is saying, that if you have any connection, any relation from these people, okay, any connection from these people, great grandfather, grandfather, 2 persons are said to be in sapinda of each other if one is a linear ascendant, one is a linear ascendant of the other within the limits of sapinda relationship, and if they have a common linear ascendant who is within the limit of the within the limits of the sapinda relationship with reference to each one of them. So now these are 5 lineal descents. Okay, 1, 2, 3, 4, 5. So from father, if there is any relation, then that person cannot marry. For example, if your father has a sister, you cannot marry your aunt. Okay, you cannot marry your aunt. In the same way, you cannot marry your aunt's daughter. So anyone who are somehow related till this line of ascent, till great great grandfather's ascent in relation to father, and to great grandmother in relations to the mother, 3 line of ascent in mother and 5 line of ascents in father, then this person X cannot marry that person, because that person will be considered to be a sapinda related to that X, to the person X. And that is why it becomes very important for you to understand that whenever there is a sapinda relationship between 2 people, if there is same line of ascent, same mother and same father, then that type of relationship is not being considered to be to allow marriage to take place. So you cannot marriage in the same pin. You must have heard that you cannot marry in the same pin, which means 3 lines of ascent towards the mother and 5 lines of ascents towards the father. If somebody falling in these lines related to your father, to your grandfather, to your great-great-grandfather, to your great-great-great-grandfather, to your mother, to your grandmother, to your great-grandmother, then the person to whom you are referring to whom the father and mother has been talked about, that person cannot marry anyone in that particular line of ascent, because the reason is they have Sapinda relationship. I suppose this is much more understood and clear to you what exactly is Sapinda relationship. And degree of prohibited relationship, two persons are said to be within the degree of prohibited relationship if they are linear ascent of the other. Linear ascent of the other. Okay. If one was the wife or the husband of a linear ascent or descent of the other. If somebody, let's take the example, this is a husband and this is the wife, talking about X, okay, or you can say it is the father or this is the mother, this is X, okay. So X mother, X cannot marry her mother, he cannot marry mother's mother, okay, neither he can marry mother's mother sister. So these are the prohibited relations. And why is it? Because it has been mentioned under the Hindu Marriage Act of 1955. If one was the wife of the brother or the father's or mother's brother, so in short, whatsoever relation you find in regards to the 3 lines of ascents in regards to mother and 5 lines of ascent in regards to your father shall be considered as prohibited degree of relationship, because they are falling within the brackets of Sapinda relationship. And that is what has been mentioned. If one was the wife of the brother or the father's or mother's brother or the grandfather's or grandmother's brother or the other, if the two are brothers and sister, uncle and niece, aunt or nephew, children or of brother and sister, or 2 brothers or cousins. So these are cousins. You cannot marry in your cousins also. This is because they are within the prohibited degree of relationship. For the purpose of clause F and G, that is this clause, relationship by half a uterine blood as well as by full blood. So this is also illegitimate blood relationship as well as legitimate. Relationship by adoption as well as by blood. All the terms of relationship in those clauses shall be considered accordingly. So whether it is a half blood, whether it is a full blood, whether it is a uterine blood, but they are within the prohibited degree of relationship, that is, so they are Sapinda related to each other, then their marriage cannot be allowed, because it is falling within the prohibited degree of relationship. Okay, so this was a very important portion. It was very important for you to understand that what is Sapinda relationship, that the questions will be in from this particular relationship only, that this person married X person who happened to be in the 5th line of descent of mother. 5th line of descent of mother. And we have studied that it is only till the 3rd line of descent that there is a prohibited degree. So whether that marriage can be considered as a valid marriage? Yes, the marriage can be considered as a valid marriage, because they are falling outside the scope of the prohibited degree of relationship. So that is something that we needed to understand, because in CLAT you will be getting a question from at least Sapinda relationship, and once you have understood this concept, it will be very much easier for you to figure out whether the person is falling within the brackets of prohibited degrees or not. We have to remember that it also includes half blood, uterine blood, and adopted children also. And if at all these people are falling within the brackets of this prohibited degrees, then they are not supposed to get married. So we have completed till the Sapinda relationship. We will continue forward with the Hindu Marriage Act in our upcoming lectures, in which we will be discussing about the overriding effect of this act, what are the conditions of the Hindu marriage, and then we will be studying about ceremonies of Hindu marriage. What are the ceremonies that needs to take place? We talk about Saptapadi. We will be talking about or any other grounds that needs to be fulfilled, and then whether the registration is compulsory or not. Then we will studying about the restitution of conjugal right and judicial separation also. So we will be dealing in each and every aspect of the Hindu Marriage Act for your better understanding and for your CLAT perspective. All you need to do is to, again, I will be reminding you of what you need to do. What you need to do is you need to study this till this particular portion, Sapinder relationship, and to understand what exactly is Sapinder relationship, what exactly is Hindu Marriage Act. I would not ask you to study each and everything, but till what I have provided information, I would like you to go and again revise it, because we are again following the same principles, same practice is needed, and persistency is needed in order to make sure that we qualify our CLAT examination. With this, I would like to thank you all for being present in this particular lecture series. We will continue with the Hindu Marriage Act in our upcoming videos. Till then, thank you so much, guys. May you have a good day. Bye-bye. Take care.